we create precedent as well, that it undermines the Supreme Judicial Council. Supreme Court is not a watchdog over. However, like every other constitutional body, when a constitutional provision or a fundamental right is being violated by anybody or not being considered, let's both ways, then the Supreme Court is the only court which has the power, or the High Court, not in this case, to direct that this be done.
Yes.
So we have to be very careful how we proceed in this matter, because it will, like you are citing Justice Clark's case after 50 years, this will become precedent and it will be cited before us maybe earlier than 50 years. So we have to be very careful as to not disturb the perfect balance that the constitution makers have provided in the constitution.
There is an intervening judgment 2018 की, उसमें ये सारे एस्पेक्ट्स बहुत अच्छे डिस्कस हुए हैं और उसमें ये आया, उसकी हैसियत क्या है ये भी डिस्कस हुई है. मेरी गुजारिश है उस जजमेंट को जरा PLD 2018 सुप्रीम कोर्ट 538. I was counsel that again Shaukat Siddiqui's case.
This is Iftikhar Chaudhry's case.
This is PLD 2018.
वो अच्छा एक और जो आपका मैटर नहीं ये नहीं का है, ये तो आप ही का केस है ना.
जी वही. इसमें ये एस्पेक्ट प्रोसीजर एस्पेक्ट्स बड़े डिटेल में डिस्कस हुए हैं.
Which part you want to read from?
जी अब मैं आपको वो जो है ना बताया कि वो मेरे नोट्स निकाल लो, नहीं दूसरे वाले नोट्स में.
पेज 5559 पे आ जाए.
538 से जनाब
पेज 5559 पे पैराग्राफ 51.
My Lord, my lords, am I needed for these proceedings, or can I be excused for now?
Is there something urgent?
Yes, I have. There's a matter which I have to argue, not before.
Okay, fine. ठीक है.
But
कोई बात हुई उनको बता देंगे. But you've noted the points.
I have.
ठीक.
Sir, this judgment is very thorough judgment discussing various aspects of Article 209. पहला जो point out करूँगा वो page 555 है, para 46.
जी.
Historically, page 555,
historically,
46. Historically, the fundamental rights of the people require protection from the excess of the executive and the vested interest, both commercial and political. In order to safeguard the fundamental rights of the people guaranteed under the Constitution, the independence of judiciary obviously must be insulated from the onslaught of the executive and such vested interests who are past masters at institutional capture. Thus, the security of tenure of judges, more so those of the superior courts, is imperative, and therefore adequate safeguards in this behalf are provided, including by enacting what appears to be a rather cumbersome and strict process of their removal. This cardinal principle is reflected in the constitutional dispensation of all the democratic countries, people by citizens and not subjects. The exception in this behalf are almost always found in...
Fine, you don't need to say this, it's obvious, जी.
नहीं सर, एक ये बात जो एक बहुत important aspect है वो जनाब देखिए पेज 559, ये जरा पैरा 51, ये जरा जरूर देख लीजिए.
पेज
559 पैरा 559 पेज पैरा 51. The relevant provisions of the Constitution more particularly Articles 209, 210 and 211, when examined in the light of the judgment handed down by a larger bench of this court in the case reported as Chief Justice of Pakistan Khan Muhammad Chaudhary, and the previous pronouncements on the subject noted and quoted with approval in the aforesaid judgment, the relevant portions whereof have been reproduced in extenso herein above, should reveal that, firstly, the SJC is a unique forum created by the Constitution. Secondly, the SJC is not a court, though it may exhibit some of its trappings, including the power to punish for contempt. So it is not a court. Yes, year 2010 की judgment भी. Thirdly, the proceedings before SJC are essentially a fact-finding inquiry, sir. This is what I am submitting here. This is the function of the SJC. Fourthly, the SJC is akin to a domestic forum and it conducts administrative proceedings regarding the question of conduct or capacity of a judge who is to be judged by his own peers. Fifthly, the findings of SJC are recommendatory in nature and do not enjoy the status.
So, yes, agreed. What is the point you want to make?
I'm trying to make here is a domestic forum. Your Worship was saying that it's just like as if it is some kind of a rival court to Supreme Court. No, it is a domestic body.
No, it is not. It's a constitutional body.
It's a constitutional body.
So, what happened in this case? Why did you come to court? What relief did you get or not get?
इसका primary function जो है वो inquiry है.
नहीं, ये फैसला जो आप साइड कर रहे हैं, ये क्यों आया आपका केस सुप्रीम कोर्ट में?
ओपन इंक्वायरी
केस क्यों आप लाए सुप्रीम कोर्ट ये वाला?
ये इसलिए कि हमने कहा था कि इस केस में कि हमारी ओपन इंक्वायरी होनी चाहिए.
तो सुप्रीम कोर्ट ने क्या फैसला किया?
सुप्रीम जुडिशल काउंसिल ने कहा नहीं, इट शुड बी इन फोरम. इस केस में
फिर तो आप ये ग्रीवेंस दोबारा एजिटेट नहीं कर सकते हैं ना हमारे सामने.
नहीं, बात क्या हुई, इसमें उन्होंने अलाउ कर दी ओपन इंक्वायरी. This judgment allowed open inquiry subject to certain conditions.
वो पैराग्राफ किधर है?
जी वो उधर भी आ जाएगी. It's a very historic judgment in that case में
आप कहते नहीं अलाउ हुई
हैं?
सब SJC
कि क्या फायदे?
वो वापस भेजा है ना सुप्रीम जुडिशियल काउंसिल 577 पैरा 96.
वो एक
Consequently, the question regarding the conduct of proceedings.
नहीं, तो ये तो वो रिमांड हो गया ना. ये केस रिमांड का केस है.
नहीं, इसमें उन्होंने कहा कि
नो हामिद खान साहब
सब्जेक्ट टू सच.
हम जो इतनी देर से आपसे सवाल पूछ रहे हैं, ये पैराग्राफ 96 जो माय लॉर्ड ने पॉइंट आउट किया, सब पढ़िए.
नहीं वो ठीक है,
आप पढ़िए तो.
सर बात ये है,
आप पहले पढ़े तो ना 577 पे.
Consequently, the question regarding conduct of proceedings through an open justice as requested by needs to be revisited and decided afresh by SCG, not standing uninfluenced by its order dated so and so. जो order set aside उन्होंने किया.
आप पढ़े ना.
In the light of the observations made herein above. In the light of the observations.
So this is
observations क्या हैं?
एक सेकेंड
जी.
सर हमारी बात सुन लेना. अभी हम आपसे बार पूछ रहे थे रिमांड, तो ये रिमांड ही तो किया है.
पिछले सवालों का जवाब है
तो ये पहले सवाल का जवाब इधर मिल रहा है.
मैंने भी तो रिमांड ही मांगा है.
नहीं, अगर आपने बताया ही नहीं, आप कोई और वजह से बताया.
मैं ये कह रहा था कि उसमें
फिर क्या किया सुप्रीम जुडिशियल काउंसिल ने इस ऑर्डर के बाद?
इस ऑर्डर के बाद उन्होंने अलाउ की थी. इन दैट पर्टिकुलर केस अलाउड ओपन हियरिंग.
वो ऑर्डर कहाँ है?
वो कोई दूसरा रेफरेंस था?
वो दूसरा रेफरेंस, वो रेफरेंस 242 है.
अच्छा, ये केस नहीं है.
इस केस में जो इस केस में इम्प्यून था वो रेफरेंस 242.
लेकिन इस रेफरेंस की तो बेसिस जो है वो तकरीर है, और उस तकरीर को आप डिनाई नहीं कर रहे हैं, उसके कंटेंट्स को.
ठीक है, but then that has to be inquired into. तो मेरा गुजारिश ये करनी थी, जो जनाब के ऑब्जर्वेशन थी.
That reference was dismissed. What happened?
That was never decided.
You want that
ये प्रोसीडिंग्स टेक हो।
You want that be also be decided. आप चाहते हैं कि उसको भी डिसाइड करें?
नहीं सर, बिल्कुल
नहीं, इसकी बात नहीं, मैं तो आपके सामने आपका प्रेसिडेंट दिखा रहा हूँ कि प्रेसिडेंट ये है। फिर उसमें इंक्वायरी का तरीकाकार इसमें बड़ा अच्छा तरह डिस्कस हुआ है, वो भी जरा देख लीजिएगा। उसमें उन्होंने कहा कि ये जो इंक्वायरी होगी सुप्रीम जुडिशल काउंसिल की, उनके ये पैरामीटर्स होंगे। मैं उसकी तरफ जनाब की तवज्जो दिला रहा था। वो तो आखिरी में उन्होंने कहा कि जी ठीक है, रिमांड कर रहे हैं आप, इस जजमेंट की लाइट में आप डिसाइड करें। परफेक्टली ऑल राइट। वो एक पहला था, मैं कहा था इंक्वायरी में ये कुछ होना चाहिए।
तो खत्म।
जी सर, सो मेरी गुजारिश ये है कि all the judgment so far says that a judge cannot be removed on the basis of a report which is not based on inquiry, and this is the case. Without inquiry, the Supreme Judicial Council has submitted a report in which they have recommended the removal of the judge, and therefore that is clearly an unconstitutional void non-est order. About what Lordship was saying, उसके बारे में मेरी गुजारिश ये है कि प्रोसीडिंग्स में शो कॉज नोटिस हुआ एक, उसके 2 दफ़ा, पहला प्रिलिमिनरी रिप्लाई, फिर एडेड रिप्लाई, ये हुआ। उसके बाद एक एप्लीकेशन मैंने दी जिसमें मैंने कहा कि अगर अव्वल तो ये addressing a bar association is not a misconduct, but in case you want to hold inquiry, please hold it in open court. वो जजमेंट वो भी मैंने दिखा दिया। उसके बाद उससे 2 दिन बाद जब हियरिंग हुई, उसमें ये सारे सवाल आए और उसमें हमसे ये पूछा गया कि हाँ इंक्वायरी है, हमने बिल्कुल ये तकरीर की है, ठीक है।
नहीं, एक सेकेंड। सो देयर वर 2 रेफरेंसेस, एक में अलाउ हो गई आपका ओपन और दूसरे में नहीं अलाउ हुई।
नहीं, दूसरे में तो
आपने कहा था, आपने दरखास्त दी थी ना ओपन के लिए।
सर वो तो ओपन क्वारी का तो प्रेसिडेंट बन चुका था, ओपन क्वारी का तो प्रेसिडेंट हो चुका था।
अभी आपने कुछ देर पहले कहा कि उसमें इंक्वायरी ओपन नहीं हुई थी, मैंने रिक्वेस्ट की थी।
उसमें नहीं हुई,
तो एक में किया और एक में नहीं किया,
इसमें नहीं किया।
और फर्क क्या है दोनों में?
फर्क ये है कि आफ्टर, इसमें तो इंक्वायरी सिरे से नहीं हुई ना, उसमें
नहीं, मैं अब इंक्वायरी की बात नहीं कर रहा हूँ, मैं अब कह रहा हूँ प्रोसीडिंग्स के वो प्रोसीडिंग्स ओपन करें जी, वो इन कैमरा ना करें। एक में तो आपकी दरखास्त अलाउ हो गई जी आप कह रहे हैं, बिल्कुल, वो है रेफरेंस नंबर 242 में, 242। मगर इस केस में इसका रेफरेंस नंबर क्या था?
मौजूदा रेफरेंस।
हाँ, इसमें आपने कहा नहीं हुई,
इसमें तो इंक्वायरी नहीं हुई सर।
क्या इंक्वायरी इज अ सेपरेट थिंग, ओपन प्रोसीडिंग्स की बात कर रहा हूँ।
ओपन प्रोसीडिंग्स देखो, प्रोसीडिंग्स इंक्वायरी की होनी थी ना, इसमें सिरे से इंक्वायरी नहीं हुई।
नहीं, वो एक अलग पॉइंट है, प्रोसीडिंग्स ओपन हुई या नहीं हुई?
इस एप्लीकेशन पे कोई ऑर्डर नहीं हुआ, यानी जितनी प्रोसीडिंग्स।
इसका नंबर क्या है रेफरेंस का, ये वाली मौजूदा का?
347। जितने
ठीक है, समझ गया
ओपन नहीं हुई।
Got it. ठीक है, खत्म। Can we ask Mr. Salahuddin? We want to wrap it up. Mr. Salahuddin, you've been hearing everything?
I was not able to be to Islamabad because of lack of availability.
What is the way forward? Address that point only.
My Lord, my submission is that the report and the notification is to be set aside on the ground of being malafide in law.
Please tell us the way forward.
Yes, sir. My submission is that it cannot be remanded to the SJC. The SJC scope is limited under Article 209. However, this court, if it considers fit, and I would urge that
who do you represent? Who do you
the factual merit.
Take second, who do you represent?
My Lord, the Bar Association, Karachi Bar Association, and the
so you basically you don't want the truth to come out.
No, sir.
Yes.
In fact, my petition is.
You are saying. Please hear us. You are saying that the relief should be given to the petitioner, but the people of Pakistan should be kept in the dark because they can't handle the truth. So why can't it be remanded? Why are you saying it can't be remanded?
No, not at all, sir. I'm not saying that it should not be investigated. My submission is that the proper forum would either be this court itself or a commission appointed.
We are not seeking your opinion, we are seeking some legal response. In my opinion, that doesn't help us, does it? Why can't it be remanded?
It is because of the language of 209 itself, sir.
Where does it suggest that? In fact, Mr. Hamid Khan has just cited a case where it was remanded, the matter was remanded.
इसमें ये जो केस इन्होंने रेफर किया है इसको डिस्कस करा है इनके ऑर्डर के पेज नंबर 15
It cannot be remanded. If Mr. Shafik Siddiqui was still now.
We can't, voice has gone.
48
नहीं तो इससे पूछ लेना वो करेंगे ना
So the council to recommend his removal. Therefore, it does not have then the jurisdiction under 2096. And so the remand right now cannot be done. It could have been done 2 years ago. But right now, the remedy is that uncertainty those allegations.
So you mean to say, you mean to say, on account there is a well-settled principle that no one should suffer as a consequence of act of court. So you're saying because the court delayed the matter for 2 years, the petitioner's valuable right has been taken away from him. Is that your argument? We can't hear you. You're not speaking clearly. करें ना ठीक इसको.
That the civil servants actual tenure has ended.
Civil servant को आपने judge बना दिया. अब आप please don't.
Disciplinary proceedings का principle तो वही है sir.
No, it's not. Please, no, don't do this. If you're reducing a constitutional office to the level of a bureaucratic thing and saying the same principle applies, with respect, I will not agree with you.
My submission is that the stigma around a person's reputation caused by wrongful removal, that is something that he is entitled to remove, even if he has finished his age of service. It is the same principle which your lordships entertain appeals against convictions, even when
Mr. Salahuddin, please focus on the Constitution. Mr. Hamid Khan has read 2095, which says inquiry, then 2096, which talks about inquiry, and you are saying there's no need for an inquiry because he's retired, he's at age of 62, so even if SJC did not comply with the Constitution, so let him suffer.
Yes, sir. What I am saying this court is to set aside the report of the Supreme Judicial Council and the President's notification on account of being without jurisdiction and then
we are asking you, can it be remanded or not? We're not asking you, can it be set aside?
My solution is the reason the factual allegations cannot be investigated anymore by the Supreme Judicial Council is because
are you saying that we should take over the functions of the Supreme Judicial Council? That's the only solution then. There's no other way. Either they do it or we do it.
The Supreme Judicial Council has a specific rule.
Mr. Salahuddin, you're not providing us any solution. You are saying the Supreme Court should assume the functions of the Supreme Judicial Council.
Right, sir. The Supreme Judicial Council will end if a judge, for whatever reason, is no longer there.
Then why are you saying for whatever reason we are dealing with a real case?
Yes, sir. He has crossed the age of superannuation.
So he should suffer. He should suffer because of that.
No, I'm not saying he should suffer.
I don't know.
I'm saying the order can be set aside
without conducting inquiry. We should set aside the order. Why?
My lord, the order should be set aside because
No, without inquiry.
jurisdiction.
No, without
That is-
inquiry.
Irrespective of the merits of the case, the order is without jurisdiction, therefore it deserves to be set aside. It is without jurisdiction for two reasons. The first reason is, sir, that the inquiry was not initiated
If you are arguing in this manner, what provision of law have you filed your petition under?
184.3.
What's the first word in that? Then you don't have a case. Then we should dismiss your petition on that ground alone, because you're arguing against your own petition now. You are saying you are now claiming the right of an individual and not the public's right. Please read 184.3. It starts with the word public importance. So you are now pleading the case of the petitioner, not the public's. You're not saying exactly what you're doing. You say public should not know the truth of the matter. Please give him his pension and that's it.
So there are two aspects of public importance.
आप पढ़ तो लेना 184.3. 184.3 पढ़िए ना जी.
So the first aspect of public importance is that whether the SJC has the legal right to remove judges without a factual inquiry. That is a question of public importance. The second question of public importance here, which is separate, is whether the allegations of Mr. Shaukat Siddiqui were correct or not. That has to be investigated separately. My only submission is that the SJC no longer can do so. The reason I am saying this is, sir,
you don't. When you say a statement, back it up. That has to be investigated separately. I'm quoting your words. How? That's the only question we're asking you.
Your lordships, in 184.3, your lordships can.
I'm just quoting you. I'm quoting your words. Who will investigate? We. Say, tell us.
The truth of the allegations can be determined by this court.
So we'll record evidence. We will record evidence. We will record evidence.
There's no bar to it, sir. But if your lordships feel that
feel की बात तो नहीं हो रही है. You are assisting in the court. We don't go on feelings. Assist the court on the constitutional point, not on our feelings.
My lord, there is no bar under 184.3 to recording of evidence. It is done even in constitutional petitions under Article 199.
ये तो आप हमें वे फॉरवर्ड हम बार बार पूछ रहे हैं ना, वे फॉरवर्ड बताएं.
गुजारिश ये है कि it may be referred to a commission.
Sir, if you can speak slowly, we can't hear your words.
माइक से थोड़ा पीछे हो जाए. माइक से थोड़ा पीछे हो जाए.
Ji, sir. My submission is that it may be referred to a commission that inquires into the factual truth or otherwise of his allegations. Because I completely agree that the allegations are of such a nature that the public has a right to know whether they are true or not.
Where does the Supreme Court have this power to appoint a commission?
My lord, the power is 184.3 and...
No, don't just say these things. Read the language. Where does it say Supreme Court can appoint a commission?
Without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of public importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the...
आपको अहम खबर से आगाह करें कि नवाज शरीफ और मरियम नवाज लाहौर के हल्का NA 130 में इंतखाबी मुहिम का आगाज़ करेंगे। मोहनी रोड पर नवाज शरीफ मरियम नवाज की आमद से कबल इंतखाबी मुहिम के लिए 2 शेर लाए गए हैं। नवाज शरीफ NA 130 से इलेक्शन में हिस्सा ले रहे हैं। इसी पर मज़ीद बात करते हैं अदनान भट्टी से। जी अदनान, कहिएगा।
जी, साबिक वज़ीर-ए-आज़म नवाज शरीफ जो है वो NA 130 से इलेक्शन में हिस्सा ले रहे हैं और उनकी जो बेटी है मरियम नवाज वो आज इंतखाबी मुहिम का यहाँ से आगाज कर रही हैं। मोहनी रोड का ये इलाका है जहाँ पर वो कारकुनान से खिताब भी करेंगी। उनकी आम से कबल 2 शेर जो है वो लेके आए गए हैं, लेकिन ये याद रहे कि जो वाइल्ड लाइफ अथॉरिटी है और जो डिपार्टमेंट है उनकी तरफ से ये सख्ती से ममानत है कि इस तरह सरेआम जो शेर हैं वो नहीं लाए जा सकते, और जो भी इस तरह के शेर नजर आते हैं वो तहवील में ले लेते हैं। लेकिन अभी तक शायद वाइल्ड लाइफ की आंखें बंद हैं कि उनको ये शेर दिखाई नहीं दे रहे। ताम मरियम नवाज की आम से कबल जो शेर 2 लाए गए हैं वो उनकी इंतखाबी कैंपेन के लिए लाए गए हैं, ताकि जो लोग हैं वो भी यहाँ पे जमा हो और ज्यादा से ज्यादा जो हजूम है वो उनसे वो खिताब कर सके। खवातीन के लिए अलग यहाँ पे इंतजाम किया गया है, और ये कहा जा रहा है कि 3 से 4 के दरमियान जो मरियम नवाज हैं वो इंतखाबी कैंपेन के लिए मौनी रोड पहुंचेंगी और कारकुनान से खिताब करेंगी। रैली की सूरत में वो यहाँ पे आएंगे और फिर थोड़ी देर यहाँ पे क्याम के बाद वो यहाँ से रवाना हो जाएंगी। उसके हवाले से जो बैनर्स हैं और जो फ्लैक्सेस हैं वो भी अवेजा कर दिए गए हैं। नवाज शरीफ की जो तस्वीर है
ठीक है अदनान, बहुत शुक्रिया। एक दफ़ा दोबारा आपको बराह रास्त लिए चलते हैं सुप्रीम कोर्ट में, जहां पर साबिक जज शौकत अजीज बरतरफी केस के खिलाफ अपील पर समाअत जारी है।
Physical or mental incapacity may have been guilty of misconduct. The President shall direct the Council to, or the Council may, on its own motion, inquire into the matter.
That's a very point we've been saying. Inquire. Admittedly, SJC did not do that. And I'm not following you at all. You're not citing any precedent, or you are just saying, in my opinion, feelings. I mean, let's go on the Constitution. What does it say?
My lord, the Constitution says that the SJC can inquire into the conduct.
That's the whole point. They did not inquire. That's a case. Hamid Khan's case is.
Yes, if I may explain, sir. If I may explain.
It's not an explanation. It's a fact. Either they did or they didn't. They did not inquire.
This is admitted fact.
Sir, if the SJC report and the President notification is set aside, does Mr. Shaukat Siddiqui automatically become a judge of the High Court? No, he does not. And because he does not become a High Court judge, then the SJC cannot inquire.
At least he will get the status of ex-judge of the High Court. Former judge. He will get the status of ex-judge of the High Court.
Exactly. And there is nothing in 2095 that allows the SJC to inquire into the conduct of an ex-judge. Then if your lordship sees 296 has to be
at that time,
आप देखिए, there's a settled principle of law. When a list comes before a court, it has to be decided at what was there at that time. Not aaj law ye ho gaya. Suppose a crime is created today, we will not decide it as today. We will decide it when the law was at that particular time. It's well settled principle. Unless specific retrospectivity is given to something. So merely saying these things, we can simply avoid what you are saying, that the list before the SJC, we are considering matters, we're going back, traveling back in time. Whether time is moved forward or not, whether he's attained the age of 65, 62, are all subsequent events, coincidental events, which one view is they are very material, that the minute the watch goes forward, 62 is struck out of court. I gave an example, you were not listening maybe, that before he could file a petition, the next day he retired. So he has no remedy, then you can say, yes, he has no remedy. Let's at least be on the same line. I mean, then I can appreciate it if you use the same logic. But you're simply saying because he's retired, that's it. So then he's condemned. You can drag on proceedings, you can curtail a proceeding.
That is the opposite of what I am saying. I am saying that if a person retires...
But we are not talking about if a person, we're talking about a judge. This is not a bureaucrat here before us. Let's use the word judge.
Right. If a judge retires, and your lordship comes to the conclusion that the SJC order was without jurisdiction.
We are not saying that. No. We are not saying that at all. You've not been following. We are simply focusing on one point and one point alone. No inquiry was held. Without jurisdiction, we are certainly not saying, yes, Supreme Court had jurisdiction.
My humble submission is that factual... the lack of a factual inquiry renders those proceedings forum non juris and without jurisdiction. If there are factual aspects that have to be looked at into, and the domestic forum or the SJC doesn't look into it, then that renders the decision of that forum without jurisdiction and malafide in law. It is
this you are arguing on the basis of a normal petitioner. Then why should we entertain your 184(3) petition? Where is the element of public interest? We will concern ourselves with the petitioner, the judge before us. You have got no concern with the matter then. If this is your argument, if you merely want him, whatever, that order set aside, how does it benefit or not? Or how does it, for independence of judiciary, transparency, right of information of the public, then you've removed the entire public importance aspect of the case from your case. Then we should not hear you. We should dismiss your petition. We should just hear Mr. Hamid Khan. If you're taking away you're removing all the public element from it. If the public element is removed, then how are you invoking the 184(3) jurisdiction? The same question, Mr. Khan has also come before us in 184(3). On the thing, it's not just me, it's independent of the judiciary. I mean, has the independence of the judiciary been restored because now he'll be entitled to pensionary rights? Is the truth not important anymore?
My lord, it is certainly important, as I have said, but forum is different. But what I'm saying is the public importance is there, because if the Supreme Judicial Council removes a judge of a superior court without holding a factual inquiry, then your lordship has to declare that.
You are repeating yourself. Then I don't think you're going forward.
Salahuddin Sahab, ये Supreme Judicial Council Procedure of Inquiry 2005, इसका Section 8 Subsection 7.
जी सर.
वो जरा पढ़ें आप. Without prejudice to the foregoing, the Council shall have inherent powers to adopt any procedure specific to the inquiry which is considered by Council to be just and proper in the circumstances. और उसके बाद मैं आपसे कहूंगा जरा पेज नंबर 48 पे इम्प्यून्ड ऑर्डर जो है इसका पैराग्राफ नंबर 15 पढ़ लीजिए जरा आप. पेज नंबर, ये हामिद खान साहब की जो पेपर बुक है इसका पेज नंबर 48 और पैराग्राफ नंबर 15.
जी सर.
ये पढ़िए जरा. आफ्टर हियरिंग द लर्नेड अटॉर्नी जनरल.
जी. After hearing the learned Attorney General for Pakistan and Justice Siddiqui at his learned counsel and his learned counsel at great length, the matter was adjourned by the Council to 8/10/2018 for deliberating upon the respective submissions and to determine the way forward, keeping in view the peculiar circumstances of the matter at hand. The Council met again on 8/10/2018 and the entire matter was deliberated upon from diverse angles. It was pertinently observed by the Council that Article 209(5) of the Constitution of the Islamic Republic of Pakistan authorizes the Supreme Judicial Council to inquire into conduct of a judge of the Supreme Court of Pakistan or of a High Court upon a direction of the President of Pakistan or on basis of an information received from any source or on its own motion, and Supreme Judicial Council Procedure of Inquiry 2005 prescribes the mode of conducting an inquiry. I think, if your lordship, if I may skip a few and go to the about 10th last line of the next page.
जी आप 10th last line 4th line से पढ़े. It was इनका जजमेंट का रेफरेंस दिया गया है. जो हामिद खान साहब ने जो रेफर किया है इसके जजमेंट का रेफरेंस दिया है इसमें. ये पढ़े आप. इसी कंटिन्यू करें इसको आप.
जी सर. जी.
In the case of Justice Shaukat Aziz Siddiqui and
in the case of Justice Shaukat Aziz Siddiqui, the Supreme Judicial Council procedure of inquiry was held by the Supreme Court of Pakistan.
KPLD 2018 Supreme Court 538 इसका रेफरेंस है. जी कंटिन्यू करें.
जी. To be constitutionally valid and compliant with university accepted principles of due process. In the present matter, initial scrutiny of information was conducted in terms of para 7 of the said procedure of inquiry.
ये जो मैंने पढ़ा था.
a discussion and inquiry into the information was undertaken in terms of para 8 of the procedure of inquiry. A decision was taken to proceed against Justice Siddiqui, and a show cause notice was issued to him along with the supporting material calling upon him to explain his conduct. And after receipt of his 2 replies, the council had met and they decided to proceed further with the matter in terms of para 9 of the procedure of inquiry. And thereafter, the Attorney General for Pakistan was required to conduct the proceedings in terms of para 10 of the procedure of inquiry. After that stage of the proceeding, the said procedure of inquiry remains silent regarding the procedure to be adopted or followed in a given inquiry. And the council is extended the necessary discretion to adopt any procedure which may be found by it to suit the requirements of the inquiry. Such discretion of the council is manifestly explicit from the contents of para 8(7) of the procedure of inquiry, according to which, without prejudice to the foregoing, the council shall have inherent powers to adopt any procedure specific to the inquiry which is considered by the council to be just and proper in the circumstances. As the proceeding against Justice Siddiqui were based squarely upon the making of the above-mentioned speech by him and the multiple and pervasive allegations leveled by him.
इसमें वो बताना चाह रहे हैं सलाउद्दीन साहब, इसमें बताना चाह रहे हैं कि हमने इंक्वायरी कर ली है। इनका कहने का ये मकसद है कि इंक्वायरी हो चुकी है, हमने अपना प्रोसीजर अडॉप्ट कर लिया। आपसे एक सवाल, आपकी बात अगर तस्लीम की जाए कि इनके हद तक सेटिस्फाइड कर दें, इनका स्टेटस बहाल हो जाएगा, और दूसरे पोर्शन में जो इंक्वायरी आप कहते हैं वो अलग से कंडक्ट हो। सपोज हम आपकी बात मान लें, इंक्वायरी कंडक्ट होती है, उस इंक्वायरी में ये हम ही करते हैं और ये साबित होता है कि इनकी एलिगेशन गलत थी, फिर क्या होगा? इनका स्टेटस वापस लिया जाएगा? कौन लेगा?
सर, इसमें फिर ये होगा कि there would be it would be go then before the relevant criminal court perhaps, because there would be a question of perjury, there would be a question of
the ex-judge of the High Court will face the criminal charge without the intervention of the Supreme Judicial Council.
My lord, judges are not above the law.
No, the Supreme Judicial Council, they have to face the consequences through the Supreme Judicial Council.
My lord, with respect, if someone commits the act of criminal defamation,
no, we don't want these analogies which are not applicable to Supreme Judicial Council or to judges. Let's stay focused on the Supreme Judicial Council, on judges and the Constitution. We don't need any analogies. If you can throw any further light, please continue.
No. My lord, I'm not making an analogy with respect, because
please let it go. If you want to contribute, we don't want these analogies.
My lord, this is what is the statement. If the statements are false, then it's not a matter of analogy, then there are consequences for false statements on both sides.
I don't. If I was to deconstruct what you're saying, first of all, it's a never-ending thing ever. Let's take logically what you're saying, as what my lord had put to you, that if the petitioners this order is set aside on the basis that no inquiry was held, and subsequently a commission, okay, it's magically formed, we go along with that, and the commission, where is the commission? It's not a court of law, it's not a constitutional body, it's a sub-statute body, naturally, or a body created by an order of a court. It can either be one or the other, not a third one. That finding will prevail over the Supreme Judicial Council, will prevail over the Supreme Court, and on the basis of what this inquiry is held, either pursuant to order of the court or the Supreme Judicial Council, a judge can go to jail for perjury. This is the sum total of the argument. I don't follow this.
Let me explain myself, sir. It will not, obviously, the report of the commission too does not automatically affect.
First tell us who creates this commission.
It is formed under the Commissions of Inquiry Act, and if your lordship sees in the act,
if a commission of inquiry determines something that this judge had not stated the truth earlier, he will be persecuted for perjury.
my lord, it prepares a report. That report is then forwarded to the relevant body.
भैया आप ये बार-बार ये चीजें कह रहे हैं ना, vagueness, relevant body. We are a highest court. We want to know what is this body. Each word you must.
To the criminal investigation agency, sir.
So we are then handing over the fate of judges to some SHO or a sub-inspector in police.
If a judge makes a false allegation, he defames someone, commits libel, and it is found to be false, then he should not expect to.
Salahuddin Sahab not quite getting traction with me at least.
209 के अलावा कोई और body
कोई और बात करें या if you want to file, refer to. You are not sorry, but you're not referring to any precedent, any law, I mean these are just opinions stated at the bar. कुछ और हमें बताएं ना, कुछ चीज तो बताएं ना, कुछ आगे बढ़ने वाली बात.
मैं अगर आप इजाजत दें तो मैं थोड़ा सा ये जो पैसे
आप ऐसा करें, आप अपना राइटिंग में सबमिशंस कर दें, बिकॉज हमें समझ नहीं आ रही बात, एंड वी आर मे बी यू हैव गॉट बेटर आइडियाज, यू कैन पुट देम इन राइटिंग एंड वी विल कंसीडर देम.
May I just summarize the?
No, please do so in writing, because you will carefully think out everything, and I'm sure it will be, because if it's also 10 minutes to 2, आप हमें writing में दे दें, we will certainly consider it. हाँ?
जरा आर्टिकल 2095 मैं पढ़ना चाहता हूँ. ये कह रहा है कि इफ ऑन इंफॉर्मेशन फ्रॉम एनी सोर्स द काउंसिल or the president is of the opinion that a judge of the Supreme Court or of a High Court may be incapable of properly performing the duties of his office by reason of physical or mental incapacity or may have been guilty of misconduct. यानी कि 2095 का A या B दोनों में से कोई एक भी अगर अप्लाई करेगा तो 209 अप्लाई कर जाएगा. यानी कि लफ्ज इन्होंने और इस्तेमाल किया है लॉ मेकर्स ने. बात हुई इंक्वायरी के हवाले से, तो बड़ी बात हुई और हमने नोट भी करी, लेकिन मिसकंडक्ट के हवाले से कोई एक बात भी कोर्ट पे नहीं की गई. टॉकिंग फॉर माई सेल्फ, ठीक है. तो मिसकंडक्ट के हवाले से अगर देखा जाए तो ये जज साहब जो थे जिन्होंने के जो बातें तकरीर में करी हैं, डोंट यू थिंक दैट दिस फॉल्स अंडर द एम्बिट ऑफ मिसकंडक्ट एज पर आर्टिकल 2 जो कि कहता है कि केयरफुल टू प्रेजेंट डिग्निटी ऑफ द कोर्ट, और आर्टिकल 9 जो कि ये कहता है कि ही शुड वर्क फॉर द इंटेग्रिटी ऑफ द इंस्टीट्यूशन ऑफ जस्टिस. नाउ व्हाट आर द इंस्टीट्यूशन ऑफ जस्टिस? इंस्टीट्यूशन ऑफ जस्टिस आर हाई कोर्ट्स एंड द सुप्रीम कोर्ट्स. तो इन दो आर्टिकल्स के हिसाब से आपका क्या ख्याल है कि ये जो पिटिशनर साहब हैं ये मिसकंडक्ट के जुमरे में नहीं आते हैं? अगर थोड़ी देर के लिए हम मान भी लें कि इंक्वायरी वाला एस्पेक्ट जो है वो रह गया था सुप्रीम जुडिशियल काउंसिल से, लेकिन ये जो एस्पेक्ट मिसकंडक्ट का है वो स्क्वायरली अप्लाई नहीं करता है क्या पिटिशनर के केस के अंदर, स्पेशली इफ व्यूड अंडर आर्टिकल 2 एंड आर्टिकल 9 ऑफ दीज रूल्स? तो इस एस्पेक्ट के ऊपर हमें कोई असिस्टेंस नहीं मिली है. माजरत के साथ इंक्वायरी के हवाले से तो जरूर हमें मिली है.